I've sort of asked this question more as time has progressed. If I was a female victim and the lawyer in question was a male lawyer, would this be happening? And I just think, no way, this wouldn't happen. And this is part of the problem that we have. It's a cumbersome process. They know it. They know that it's financially draining, it's mentally, emotionally draining, that it's traumatising. And 99% of people will just say, all right, I better just, call it a day. And if they give me something or anything, I'll just walk and I'll accept it. I guess they chose the wrong victim. 1996, a friend of mine and a classmate made a statement to the police regarding abuse that we had suffered. I was one of 3 or 4 victims in the class between 1989 and 1991. So he made a statement in 1996 to police, and the police just shelved the statement. They shelved the investigation due to lack of evidence. In 2005, this same perpetrator who had been shipped off overseas because the school just got rid of him and they sent him off, he had continued to reoffend, and he subsequently got caught in St. Louis in America. And it was at that point that the police reopened the investigation, and they asked me to be a witness to that statement, which was made in 1996. They asked me to make my own statement, and they also asked me for leads to other victims which had suffered. I cooperated with them, I helped them, and there was a subsequent extradition, conviction, and custodial sentence.
A serious and unforgivable betrayal of children's trust and their regard for you. You exploited your position and power over them.
I never had any intention at all to seek compensation. It was not even something I knew that existed. I was just happy to help with the investigation, which I did. But then in 2014, I was left without a choice due to personal reasons and for reasons I don't really want to go into, but I had to make a civil litigation against the institution, which I did for that historical abuse. So I approached a law firm, and they represented me for about 3 months, or just under 3 months, and the case settled at a mediation, a half-day mediation, but the law firm that had represented me, they withheld all the compensation in their trust, and then they, by way of coercion, and I refer to it as coercion because that's what I felt, I was being coerced and being intimidated, that they said to me, look, you need to sign these authorities, which will basically amount to 8 times the original cost agreement. And they said, if you don't sign these authorities, which we're talking hundreds of thousands of dollars, the original cost agreement said $30,000 for them to settle my matter at a mediation. So I said, look, that's what the cost agreement says. Can we just stick to that? Because, I signed on a cost agreement, half-day mediation, 3 months representation. No, you have to sign this, and they withheld onto everything for over a year. And then they sent me bills, post-dated bills, without disclosures. If a law firm want to charge you, they can charge, but they have to give you prior knowledge, and they have to get your consent. That's what disclosures are. It's very specific in terms of the legislation, and there's a reason for that, because victims and people that are vulnerable, that don't know what the law is, they need to be made aware as to why they're being charged and on what basis. And it has to be in detail, and it has to be with consent. I was never provided those disclosures. They just came to me and they just said, look, you have to pay this, otherwise, we're not going to... And they effectively wanted to leave me with nothing. They wanted to take everything away. I'd already been on this process, on this, you can appreciate it's many years, and 5-6 years prior to that, involved with the investigations, involved in helping police and involved with the Royal Commission at the time. It's very, very cumbersome, it's very taxing, and so I just wanted to move on with my life, really. That's why I approached them. And here they are, holding on to everything and saying, you don't sign it, you don't get anything, and we'll effectively take everything away from you. Now, it's very hard in that predicament to fight that or to stand up for yourself, because I'm not a lawyer. Most people are not aware of what the law is. They don't understand, and they know that, and they take advantage of that. So I subsequently went to the Legal Services Commissioner. We raised a complaint to the Commissioner, and they share a building with the same law firm holding Redlick that represented me. I don't know if that's a coincidence, but they do. And so I said to them, look, this is what's going on over here, Commissioner. Could you please help me? we told them everything. We just said, look, and this is based on the evidence, this is based on the documentation, there were no disclosures, there was nothing. They took 6 months, they handed down a preliminary decision, and they said that they intend to close a decision. So obviously I contested that. I said, look, how can you do that? This is clear. It's, I'm just coming within my rights. This is what's been, it's my conversation. Can you please uphold the law in terms of, I don't know. I mean, it's not, I don't think this is rocket science. I don't think I was asking them anything unreasonable. So they took another 6 months, and then they finally handed down a final decision, and they said, look, we're going to close the complaint, nothing to see here. So I just thought, well, what am I going to do? Where do I turn to? Who do I turn to? And I understood that there is a self-represented litigants department in the Supreme Court, and that I can represent myself. So I looked into that, and I researched the law. I did studied the law, did my due diligence in that regard, and I issued a motion for review of the Commissioner's decision. My motion was accepted by the Supreme Court, and I had standing. We went into that review, and there was a full day hearing before Justice Michael Croucher. He's an experienced criminal judge, and I believe that he was fair in terms of he listened to everything that I presented. I made my case very clear, and the legislation is very clear, and it comes down to this, Avi. It says very clearly in Section 178, Part 2, that the Commissioner must investigate a law firm's their obligations in terms of upholding their obligations with cost disclosures. If a law firm has contravened their cost disclosures obligations, it is the Legal Services Commissioner which must investigate that. And if they have been found to be want in that area, that they have not fulfilled their obligations, then the cost agreement is void. That's what the legislation said. It's actually void, and they're not entitled to recover their costs. So the Commissioner was trying to argue to the Supreme Court, and they had 10 lawyers there on the day. And I just come in, I'm just a single person, I'm equal before the law, right? We all are. So based on that, I went in and I'm coming with the law, because the law is there for us. It's there for all of us. It's there to protect us. This is the main point. The Commissioner did not have discretion to choose if they wanted to investigate Holding Redlich and their cost disclosure obligations or not.
So you're saying that they never actually investigated it? What did they do for the year?
They just basically tried to fob me off. What they said to me is, you should go to the cost court within the Supreme Court. Now, the cost court is there to assess costs. In other words, if a lawyer gives you a bill of costs or an invoice and you dispute that, you can go to the cost court, and the cost court will assess what is fair and reasonable. But they cannot do that. The legislation says very clearly in 178 Part 2, the law firm cannot recover their costs until the Commissioner has investigated as to whether they've fulfilled their cost disclosure obligations. If they haven't, then there's no point in them going to recover their costs. On what basis are they recovering costs on fraudulent, post-dated bills and invoices?
So that hearing was on what date?
24th of November 2021, was 3 months ago.
And right now it's pending any day the decision?
Correct, yes. At the onset, before it reached the Supreme Court, the lawyer that was representing me at Holding Redlich, she went and took out an IVO against me, an intervention order, to try and silence me. And I had not been in contact with her for over a year. She said that, I had sent unsolicited emails, that I had threatened this, that and the other, and she was granted an IVO. And I've got it all in writing. I was always fair and reasonable. I was always courteous and respectful to my lawyer, but she has very effectively used the system as a toy. So at that point I said, okay, enough is enough. You've withheld everything. You've intimidated me and bullied me out of my rights, tried to silence me, knowing that I'm already vulnerable, knowing that I've already gone through years of trauma and been assaulted as a victim already. I'm gonna do what I need to do. So I initiated proceedings in the Supreme Court, and now I'm suing Holding Redlich, and that lawyer is a party to that proceeding.
Right now, all we're waiting for is you've got two outcomes we're looking at. One that's already played out in court, the judicial review.
Yes. At the end of the day, this is something which should concern everybody. This is a matter of public interest. The commissioners, they're getting paid $300,000 a year, taxpayers funded money, they're to protect us. They're not there for their own benefit. They're not there to protect the lawyers. If the commissioner themselves are not upholding the law, we have a real problem. I'm within my rights and I'm standing up for those rights. And if I don't stand up for those rights, then I will not be a good example to my own two boys, So that's why I'm doing it. But they have, at every step of the way, and with any which way they can, they will try to knock you down, to frustrate you, and to bamboozle and confuse you out of your rights. And I can see why most people will give up. When you're getting denied justice over and over and over again for years, and protracted delays, and justice delayed is justice denied.
Absolutely, and we'll watch closely. We'll keep a close eye on the outcome of both your judicial review coming in any day, and then obviously your matter against the law firm and the lawyer specifically with regards to your compensations. We did approach Holden Redlich for comment on the 3 allegations raised by Mr. Wallace, charging 8 times the cost disclosure of $30,000, withholding the compensation for his historic child sexual abuse, and why their lawyer filed an intervention order against Mr. Wallace once he filed a complaint with the Legal Services Commissioner, especially since Wallace says they hadn't communicated for about a year by that stage. I received a short response from the COO. Holden Redlich does not comment on confidential client matters. Read into that as you wish, but one thing it makes for certain, we'll have to wait for the outcomes of both of Mr. Wallace's lawsuits in the Supreme Court for any further real clarity. I'll be sure to update you at every stage in this story, so make sure to head over to followavi.com and firstly sign up to our mailing list, and then subscribe to all my social media accounts in case they remove me from the platform you're watching this on right now. Followavi.com. Don't ever let them censor you. Stop you from seeing the other side of the story. Followavi.com now.